Thank you all for joining this afternoon, our Terminations in 30 Minutes session. So my name is Marc Nadeau. I'm the VP of Sales with HR Covered. And we also have Anatoly, our employment lawyer, here with us today as well, who is with HRC Law. So we're both very excited to be joining all of you today to educate you around employment law and more importantly around terminations. HR Covered, so you know, is an organization who is actually able to support organizations across the country, whether it's for-profit, not-for-profit, with all of their needs around HR, health and safety, and employee relations. And HRC Law, who is basically an organization that we are working closely with, are really specialized in everything employment law. So whether it's contracts of employment, difficult matters or situations, representation in court as well. So, and we'll talk about this later today, but just at least so you know who is here and who is hosting the webinar and that you are not wasting your time with us here today. If you grab your mouse quickly on your screen, you will see something at the bottom of the screen that says Q&A. If you have any questions throughout the session, please take a look and click on there and type in your question. I will be monitoring this throughout the session as well. And if there are any questions that are very timely, I will ask them to Anatoly on your behalf right away. We'll also have a moment or a few moments for questions at the end of our session as well. And this webinar is being recorded, so everybody will actually receive a copy of the webinar once the session is over. So on that note, thanks again, everybody, for joining, and I will let Anatoly take this away.
Thank you so much, Marc. Really appreciate the introduction. Really happy to be here with all of you. Today is going to be a really fast and hard-hitting presentation on terminations. It's hard to talk about terminations in 30 minutes, but we are going to do our best to give you some really great information about terminations in a short period of time. So because I am a lawyer, we do have to provide the legal disclaimer. So today's presentation is not intended to be legal advice, to be treated as legal advice. It's a high-level overview, and your company's obligations will obviously depend on the specific facts that are applicable to your situation. Anytime you have a question, you should be contacting a qualified lawyer. Hopefully, that will be us at HRC Law, but regardless, you should definitely be seeking the advice of a qualified lawyer before taking any steps that you're not sure about. And the other thing to note is employment law changes really, really quickly. It's one of the things that I love about it, and that's especially true these days. We all saw that with COVID and how many changes to the law COVID brought. So your best course of action today may not be your best course of action tomorrow. So just think about that as we're going through the presentation. So a little bit more about me. That's a picture of me on a good hair day, I suppose. But I'm a small business owner, just like many of you are. I'm a lawyer. I've been a lawyer for 18 years. I've practiced in a bunch of different areas over the course of my career. But over the last several years, I've focused on employment law. And one of the reasons I decided to focus on employment law is, well, I'm really passionate about it. It really impacts almost everyone in society. People are obviously the lifeblood of every business, and dealing with people is really what employment law is all about. And even the courts have gone so far as to recognize that a person's employment is an essential component of their sense of identity, self-worth, and emotional well-being. And we all know that we spend a lot of time working. Sometimes we spend more time working than we do with our families, which is a whole different conversation, but suffice it to say, it's a really important area of law. It touches on almost everybody's lives, and I really am very passionate about it. So that's why I've decided to focus my last several years on employment law. So I always like to start every presentation with an agenda so you know where we're going with it. So the first thing we're going to talk about is the importance of written employment contracts. Actually, sorry, that's a bit of a lie. We're first going to talk about some definitions. It's not on the agenda, but I realize that just because I happen to know the meaning of some words and people use words all the time, it doesn't necessarily mean that everyone's on the same page when it comes to some really important words. And so we're going to provide some definitions definitions before we get into it. But then we're going to talk about the importance of written employment contracts. We're going to talk about the difference between wrongful dismissal and constructive dismissal. The reason why we're going to do that is because there seems to be a lot of confusion. I hear from people all the time that they don't really understand what the difference is, what a constructive dismissal is, and so I thought it was important to spend some time on that. And we're going to talk about statutory obligations versus the common law. Right now, you might be thinking to yourself, you're not really sure what those words mean. Maybe you are sure, but we're going to talk about that when I talk about definitions. Then we're going to discuss a little bit about just cause and whether it's worth it. Is it worth it to allege just cause when terminating an employee? We're going to have a discussion about that. And then we're going to talk about how to organize your termination to protect your liability and your reputation. And then finally, if I speak fast enough, hopefully we'll have some time for a Q&A session. Okay, so into the definitions. So the first definition we're going to talk about is just cause, or some people say fired for cause. So simply what that really means is that an employer fires someone for a reason. It's they had a reason and they're alleging that that reason is sufficient to terminate that employee's employment. And what they normally mean is they want to terminate the employment without paying the employee any termination pay. So we're going to talk about when you can do that, when you can't do that, but that's what people mean when they say just cause. The courts have given it a bit more of a nuanced definition, and that's on my slide there. And the definition the courts have provided is, it's serious misconduct, habitual neglect of duty, incompetence, or conduct incompatible with the employee's duties or prejudicial to the employer's business, or willful disobedience to the employer's orders in a matter of substance. Those types of things will justify the summary dismissal of an employee. Now, it should be noted, and I'm going to sort of harp on this, it's a very high threshold. It's hard to establish. In the employment law world, we say it's like the capital punishment in employment law. So it's the sort of final step, and courts are not really prone to finding that there was cause, and so you have to be very careful when trying to assert that you had cause to fire an employee. So the next definitions that are important for everyone to know are notice and pay in lieu of notice. So notice is under the, and by the way, I should have mentioned this earlier, this presentation is going to be fairly Ontario-centric. So when I'm talking about different definitions and I'm quoting the Employment Standards Act, I'm quoting the Ontario legislation, that's because I happen to be in Ontario. The principles do apply widely across the country. The specific pieces of legislation might be different from province to province. However, the principles will apply throughout most of the country. Okay, so back to notice. So notice simply means giving an employee written notice of an employer's intention to let the employee go. And minimum notice periods are set out in the Employment Standards Act or the equivalent legislation in whatever province you happen to be from. Pay in lieu of notice simply means the payment of money that is equivalent to the compensation that the employee would have earned during the notice period. So let's say, for example, the notice period for a particular employee is 4 weeks. So payment in lieu of notice would be 4 weeks of salary or 4 weeks of whatever compensation the employee is entitled to. Now, severance pay is a definition or a term of art that people throw around very regularly, and I'm often not sure that people really understand what severance pay means. So first of all, under the Employment Standards Act in Ontario, severance is defined, so it's an actual defined term. And what it means is that it's the severance, it's really the cutting of an employment relationship, so the ending of an employment relationship. And the obligation, though, to pay severance pay to an employee is only triggered when it's the employer that severs the relationship. So if an employee quits, obviously there's no severance pay. I'm sure everybody understands that. Now, in Ontario, severance pay is only required to be paid to an employee who has been with the employer for 5 or more years, and where the employer has a payroll of $2.5 million or more. Now, the courts have clarified finally that when they're talking about payroll, the payroll is a global payroll. So not all the employees have to be in Ontario. It's a global payroll of $2.5 million or more. Or severance can also occur when there's a permanent discontinuance of all or part of the employer's business at an establishment, and the employee is one of 50 or more employees who have had their employment relationship severed within a 6-month period. Some other definitions.
Quick question, Anatoly. I know that there's a lot of, and I don't want to slow you down, and
No
I think
problem.
there's a lot of questions around severance pay. And in the many meetings that we have with small business owners, leaders, and executive directors, a lot of people are under the impression that if they do let go somebody, they don't owe them severance pay, but then their employees are then asking for severance pay, or they receive a letter from a lawyer asking for severance pay. Should they understand that the severance piece is actually termination pay?
Yeah, so again, people use the word severance in different ways, and it's important to actually nail down how it's being used. So oftentimes when people are talking about severance, they're really talking about the complete entitlement that an employee has upon termination. So including notice, including severance if severance happens to apply under the Employment Standards Act. But they're also sometimes talking about the totality of common law damages. And when we get to the difference between statutory requirements and common law requirements, we'll talk a little bit more about that. But yes, so people do use that word very loosely, but in general, people use it to mean what an employee is entitled to upon termination. And so people talk about, oh, I got a severance package. So they mean what they mean by that, what the employer is offering them upon termination, including notice, including severance pay, including everything that the employer is willing to give them for termination. But the actual definition under the Employment Standards Act has to do with what I just talked about a few seconds ago in terms of where severance pay actually applies. So only applies for employees that have been with the employer for 5 years or more, and where the payroll is $2.5 million or more globally, or in a situation where the employer is getting rid of an entire sort of swath of their business, and you're one of the employees who happens to fall into that. So yeah, it's a hard word for people to really wrap their minds around because people use it to mean different things. But hopefully that helps. So I'm going to move on with the other definition. So common law, you'll hear people talk about common law all the time. And what common law simply means is judge-made law. So employment law is kind of a strange piece of the law because we have both legislation and judge-made law. And they don't say the same things. So it's not just that judges are interpreting the legislation, it's that there's a whole body of law that kind of operates in parallel to the legislation, and you have to know when the legislation applies and when the judge-made law applies. But common law means judge-made law. When you hear the word damages simply means the monetary compensation for wrongful dismissal established by the court. So damages is also used in other areas of law, but when we're talking about employment law, what we're talking about is the compensation that a court orders for wrongful dismissal or constructive dismissal, or be it as it may, it might be a human rights complaint or any other sort of legal action that results in monetary compensation. So wrongful dismissal, really, and we'll get a little bit more into wrongful dismissal in a second, but wrongful dismissal is when an employer dismisses an employee with insufficient notice or pay in lieu of notice, or for cause, and then no cause is found to exist. And finally, constructive dismissal is when there's been a unilateral change to a fundamental term of the employment relationship, or when the employer creates or allows a toxic environment such that the employee has little choice but to resign. We're going to talk more about constructive dismissal as well. So now I want to dive into the importance of employment contracts. And in every presentation that I give, I always point out one thing, that if you're going to learn only one thing from my presentation, I point out what it should be. And in this presentation, it should be this: the importance of employment contracts. So ideally, if I'm acting for an employer, I will tell the employer that every employee should have a written employment contract. All of your employees have employment contracts. It's just that if they're not on a written contract, they're verbal contracts, and then there's no certainty to them. So the two most important reasons to have a written employment contract is to achieve certainty in the terms of the employment relationship, and to control your potential financial and legal liabilities. So in order for a written employment contract to be useful, it has to be enforceable and up to date. And anyone that knows anything about employment law knows that courts love to not uphold employment contracts. And the reason why they're not upheld varies from situation to situation. But whenever the courts have an excuse to not uphold an employment contract, they tend to exercise that excuse. And that's because they want to give the employee as much compensation as possible under the law. Now, for an employment contract to be enforceable, you have to have the following, and this would apply to most types of contracts. Offer and acceptance. So what does that mean? That means that there's been an offer and an acceptance of that offer. Now, if somebody asks for something different than what's in the offer, then that's not acceptance. So in other words, if an employer makes an offer and the employee writes back and says, I want you to change X, Y, and Z, that is not considered acceptance. Acceptance only occurs when there's acceptance of the offer as is. I'm not suggesting that there can't be negotiations, but there's no actual contract until there is a complete meeting of the minds as to the terms and the offer is being accepted as written. There has to be consideration. So consideration simply means that each party is getting something in return. So this is especially a factor for existing employees. This is something that we hear about all the time. Employers decide that they want their employees to have a new written employment agreement, and they ask their employees to sign a new written employment agreement because their lawyer has suggested that they do so. Well, in order for that employment agreement to be valid, that new employment agreement to be valid, the employer actually has to give something of value to the employee in exchange for them signing this new contract. And that's because the employee is already employed. They're already getting a salary. So they're not actually getting anything in return for signing that contract unless the employer actually gives them something. And that something might be extra vacation, it might be a one-time bonus, it might be a raise, but it's got to be something of value in order for that contract to become enforceable. The contract has to have certainty of terms. In other words, it has to be unambiguous. It should be that everyone understands what the contract says. Now, contracts are infamous for being hard to understand, so a good employment contract will be unambiguous and easy to understand. And in employment law, this is really, really important. It has to comply with the minimum standards legislation. So if you recall, I talked about how there's kind of two regimes. There's the common law regime and there's the employment standards regime. And they kind of operate in parallel, but when you do a contract, you cannot put in the contract anything that is less than what is given by the minimum standards legislation. So if in Ontario, for example, employees get 1 week of notice or pay in lieu of notice for each year of service on termination, then you can't write a contract that will only give them half a week of notice or pay in lieu of notice for a week of termination. You've got to comply with the minimum standards of the legislation.
We have a question, sorry, Anatoly,
Sure.
that came in, and we're asking here, for long-term employees, how often do companies have to get their employees to sign a new contract of employment?
Yeah, it's a great question, actually. So I don't think that there's one answer to that question. I think it depends on the type of employee, and it depends on if there have been changes to the business and changes in the legislation, the employment legislation surrounding you. I don't think it's necessary to constantly be updating people's employment contracts, but if an employee is moving from one position to another, that's a good time to update the contract. If there's been a fundamental change in the legislation to which governs employment in that province, that's a good time to update the contract. Or if you have your contracts reviewed and a lawyer tells you that they're not drafted properly and gives you the reasons why, those would be good times to update the contract. But generally speaking, there's no hard and fast answer to that. I wouldn't say that every 2 years or something you have to update your contract. It just, you have to update it when there's a specific need to do so. And some of those examples that I gave would be good reasons to do that.
Thank you.
No problem. So just going back to why employment contracts are so important. So I've already mentioned that the two most important reasons are certainty of terms of the employment relationship and controlling liability. So I'd like to focus a little bit more on controlling liability. So the obvious area where you can control an employer's liability is terminations, because what happens is, and we're going to talk a little bit more about this in a few minutes, what happens is that absent a written employment agreement, the employee, upon being terminated, is entitled to common law damages. Common law damages are always much more generous than the minimum standards that the provincial legislation will provide. So if you want to keep your financial liability for terminations lower, you're going to have an employment contract that deals with terminations properly and limits your employees, or at least most of them, to the minimum standards of the provincial legislation. Now, COVID brought to light another really important clause that should be in everyone's employment contracts, and that's the ability to place employees on a temporary leave of absence without that resulting in a constructive dismissal. Now, in Ontario, we've had some cases brought before the courts where employees have argued that even though the legislation was changed to allow employers to place employees on indefinite leaves because of COVID, and that those leaves should not constitute constructive dismissal, the courts have actually found the opposite so far. The fact remains that if you put an employee on temporary leave and that's not allowed for in your written employment contract, then it is a constructive dismissal and the employee can sue the employer for that. The other, just a few more important reasons to have a written employment contract is the ability to capture certain conduct as justifying just cause for dismissal. I talked earlier about how it's a really high threshold to have to establish just cause for dismissal. Well, if you put certain conduct in your written employment agreement and say that if the employee engages in that conduct, it's going to amount to just cause, that's really going to help your case if you do want to pursue a just cause dismissal. It's a good way to give clarity around bonuses and whether bonuses will count towards termination pay. And it's a great way of incorporating your policies and procedures into the contract. So if you have a written employment contract and you say that you append certain policies and procedures to that contract, then the employees have to abide by those policies and procedures as part of their employment contract. And not abiding by those policies and procedures might actually give you cause to dismiss those employees, whereas if you don't have them incorporated, it likely won't. The other important reason to have employment contracts, and by the way, there are more than what I've listed here, I just don't have time for all of them, is the ability to put in restrictive covenants and confidentiality clauses. Now, it should be noted that in Ontario, the legislation now provides that you cannot have you cannot have a restriction on competition. So their non-competition agreements are no longer allowed in Ontario with regular employees, but you can still have non-solicitation agreements and you can still put in confidentiality provisions in your contracts. Okay, so turning now towards wrongful dismissal. So what is a wrongful dismissal? So basically, a wrongful dismissal simply occurs when an employer dismisses an employee and alleges cause, and it's found that there is no cause or that there is insufficient cause. Or it's when an employer terminates an employee and fails to provide the employee with sufficient notice or pay in lieu of notice under the Employment Standards Act or under the common law. And this is to be contrasted with constructive dismissal. So a lot of times we hear people talking about constructive dismissal. So constructive dismissal has a lot of the same implications of wrongful dismissal, but for constructive dismissal to exist, first of all, the employee actually has to resign the employee's position. And it happens in two situations. One is where the employer changes a fundamental term of the employment contract. So maybe it's a demotion in position, maybe it's lowering the salary or some other fundamental change, moving the employee across the country to a different office. That could be a constructive dismissal. Or It's where the employer has created or has allowed a toxic workplace environment, and it makes continued employment intolerable for the employee. Now, the result of a constructive dismissal is the exact same as a wrongful dismissal. So I'd like to talk a little bit now, and we're running pretty short on time, so I'm going to try to speed through this, but I wanted to spend a little bit of time on employers' obligations on termination from a statutory perspective and a common law perspective. Now, before we even get into that, though, there's a threshold question that people often overlook, and it's an obvious question, but all these obligations only arise if the worker in question isn't actually an employee. So people might think like, well, what do you mean? Of course they're an employee. Well, not necessarily. You have to determine if the worker is an employee or if the worker is an independent contractor. And that determination is actually quite difficult to make. We've seen cases that have been in the news. For example, Uber drivers. Everyone always thought that they were independent contractors. Well, when they decided that they could get certain benefits by being employees, they started a class action, and that class action has been certified. So it's a difficult threshold question to answer sometimes, and if you're not sure, then it's a really good idea to run that by an employment lawyer. But it's an very overlooked question to determine whether the worker in question is actually an employee. Now, if the in terms of employers' obligations, so this is something that a lot of employees don't know, but I think most employers do know, is that an employer does not need a reason to fire an employee. So sometimes I get employees calling me and say, well, I was fired without any reason. I'm like, no, that's perfectly fine. As long as the employer is giving you either enough notice, written notice, or enough money in lieu of notice. Now, if you fire an employee without a reason, that's okay. But if you give a reason, the reason has to be a legal reason. So you obviously cannot fire someone or refuse to hire someone for grounds that are protected by the Ontario Human Rights Code. So, most people know this, but things like age, ancestry, color, race, citizenship, ethnic origin, marital status, family status, gender identity, and the like. Now, in order to determine an employer's obligations, you have to do a bit of an analysis. So the first thing you have to analyze is, do you have cause to terminate the employee? And remember, cause is a very, very high threshold. So before you engage in terminating an employee for cause, you should be checking with an employment lawyer. Now, if the employer truly has cause, many people, including some employment lawyers I've heard, think that the employee is not entitled to anything. It's not actually true. The employee is still entitled to the minimum provided for in the provincial legislation. But if the employee in Ontario, this is a quote directly from the Employment Standards Act in Ontario, if the employee is guilty of willful misconduct, disobedience, or willful neglect of duty that is not trivial and has not been condoned by the employer, and the employer establishes all these elements, then the employer gets nothing on termination. The only thing that the employee in that situation will get is any outstanding salary owed to them up to the date of termination and vacation pay up to the date of dismissal. Now, if the employee is fired for cause, but the cause does not amount to willful misconduct, as per the Employment Standards Act definition, then the employee is still entitled to notice or pay in lieu of notice in accordance with the Employment Standards Act. And that is 1 week for each year of service up to a maximum of 8 weeks. However, an employee that is fired for cause is not entitled to severance pay under the Employment Standards Act. So if they would otherwise be entitled to severance pay, if they're fired for cause, they no longer are, just the notice or pay in lieu of notice. And obviously that employee will not have a case for wrongful dismissal, so there will be no damages under the common law. That is, unless, of course, they sue and prove that there was no cause or insufficient cause for the termination. So in terms of the analysis, the first thing you have to look at is, if you're not alleging cause, you have to ask, is there a written employment agreement? If not, then the employee is entitled to common law damages. If there is a written employment agreement, you have to check it and see, does it have a termination clause? If there is no termination clause, again, the employee is entitled to common law damages. Now, if there is a termination clause, you have to make sure and check with an employment lawyer, is the clause valid? In other words, is it going to be upheld in court if challenged? If it's not, then again, the employee is entitled to common law damages. If there is a termination clause and it's most likely valid, then the employer's obligations are contractual and or just pursuant to the Employment Standards Act, so notice and pay in lieu of notice as per the ESA. So what are common law damages? So unlike the ESA, it's not a mathematical calculation. There's no, I'm sorry, I realize I've reached 30 minutes. If everyone is still okay to continue on, I'm almost done. But I'm just going to continue on and try to speed through this as fast as I can.
And right before you do, I just want to say to everybody that we have tons of great questions. We are seeing your questions. We will get to all of them as well in the Q&A. Yes, continue on.
Okay. All right. So really, really quickly, common law damages. Unlike the Employment Standards Act, there's no mathematical calculation. You can't say that it's 1 month per year of service, although that is a rule of thumb that some people do throw out there. It sometimes gives you a relatively good estimate, but it's not accurate. What I can tell you is it's almost always more generous than the Employment Standards Act, which represents the minimum standards. Now, when someone comes to me and says to me, well, what do I owe this employee under common law? What I do is I use AI, artificial intelligence, and there are programs that we use now that can predict the outcome and what the employee is owed very, very accurately. And the analysis is based on several factors, and they're colloquially known as the Bardell factors. The reason is there was a case called Bardell many years ago, and in Bardell, they laid out the most important factors to be considered. Now, the factors keep growing. For example, COVID became a factor, during COVID, and there's no sort of limited catalog of factors. Each situation is looked upon based on its own facts, and then they try to apply other cases that were decided that had similar factors. Now, in my experience, the most important factor in determining damages under the common law tends to be the length of service with that particular employee. It's not always the most important factor, but it's often the most important factor. So, this is, I think, a really, really important slide, maybe the second most important slide, I think, in the presentation. So just cause, is it worth it? So oftentimes, employers will ask, like, we think we have cause to fire this employee, and we'd really like to do that. Well, the question is it worth it? So my short answer is very rarely. So especially if you have a good written employment agreement in place, which is, again, goes back to the first thing I wanted you to learn from this presentation, is that it's absolutely necessary to have that, then the much better approach is to, you already have an employment agreement in place which limits your employees to the minimum standards. So the much better approach in my experience is you're simply going to offer the employee slightly more than the minimum requirement in exchange for a full and final release. This does a couple of things. Number one, it limits your exposure financially because you're only paying minimum standards, or maybe a little bit more than minimum standards in exchange for a full and final release. And it ensures that you stay out of court and stay out of litigation, which saves you time, energy, and money. And in general, it also provides for a better workplace morale because you're not constantly in litigation with employees that you're letting go because you're taking this approach where you're not generally terminating employees for cause. Now, there are obviously going to be exceptions with egregious conduct, things like theft, violence, harassment of other employees, or specific conduct that's prohibited by the employment agreement. Now, sometimes for an employer, setting a precedent that they're not going to condone certain types of behavior is more important than the financial liability. And so, again, it's a case-by-case analysis, but my short answer is it's very rarely worth it to allege cause. And I think we're getting very close to the end here. So organizing the termination, this is kind of the last substantive point I wanted to make in my presentation. So you want to organize the termination in such a way as to protect your financial liability and your reputation and your workplace morale. So a few tips. So once you've decided to let an employee go, do it quickly. Don't let the situation fester. consult a lawyer if you can before you do it, because the lawyer can sort of guide you in the most efficient and least likely way to cause a problem between you and the employee. And again, going back to the previous slide, don't allege cause unless you really intend to rely on it. I suggest being forthright with the employee, and if you're going to let someone go without cause, then you don't need to come up with some reason. You can just simply let them go, and you don't have to come up with a reason that's not a real reason. So you want to allow time for the employee to consult with a lawyer. You don't want to coerce them into signing something, because if you do that, or pressure them into signing something, because if you do that, it's not going to stand up. And where possible, and this is one that I don't think employers do enough, is you want to help the employee find another job, whether that's with outplacement services or providing a reference letter. Now, I'm not suggesting that you lie and write a glowing reference letter if you think the employee was no good, but whenever possible, be helpful to the employee, because to the extent that the employee is able to find another job quickly and effectively, it really limits your exposure, and it makes you look like an organization that people want to work for, and I think that's really important as well. And I'm going to turn it over to Marc for just a minute, and then we'll dive into the Q&A.
Yeah, fantastic, Anatoly. And it's, I think I am actually quite amazed that you've been able to cover all of this stuff in that short amount of time. And it's probably just because of my interventions that we made it past the allotted time. So, thanks for this. And,
no, my pleasure. My pleasure.
Essentially, HRC Law offers multiple different types of services, but mainly we also offer different types of packages to help limit exposure when it comes to your legal investments or legal rights as an employer. So basically, you have access to unlimited HR or employment law legal advice. You have access to unlimited contracts of employment. So we went over contracts. We have questions about contracts. How do they work? What should be in there? When I should get them re-signed? What should I give someone who's an existing employee? You can actually have someone on your side to answer all those questions. Of course, terminations are never fun, but sometimes they are necessary for the business. You want to make sure the writing is also properly done. You want to have all the right documentation to follow this and protect your business. And again, in many cases, there are surprises, I believe. You have seen Anatoly in different situations or different clients in the past that went a different route or used different people in the employment law world, and they were charged surprises when it comes to different fees or not what was negotiated in the beginning.
Yeah, that's right, Marc. So, I've, as I said at the beginning, I've been a lawyer for 18 years. I know the legal industry really, really well. And as most of you probably also know, because you're in business or business owners, when you hire a lawyer, you tend to pay lawyers hourly fees. You tend to have to provide them with a retainer, a deposit on the fees, and it's often difficult to get appointments with lawyers or to speak to the same lawyer about a specific issue because there's various lawyers touching your case. Now, with HRC Law, we do things a little bit differently, and in fact, we created HRC Law to be different, and not just to be different for the sake of being different, but because we think it's going to work much better for our clients. So we don't believe in hourly fees whatsoever, and we don't believe in those because we don't think that hourly fees align the interests of the employer and the law firm. We think that we want to be able to have relationships with our clients, and the way to do that is to encourage clients to speak to us. Well, clients aren't going to speak to their lawyers if they're worried that every time they pick up the phone that they're going to be charged, for the phone call, for the email, or for whatever other piece of communication they're going to exchange. We want to know our clients. We want them to feel free to contact us as needed. So we don't believe in hourly fees. We do not take a retainer in advance of our fees. We believe in a relationship built on trust, and we have a very simple model of a monthly subscription fee, and that's really all there is. There are no hidden fees on top of that for the packages that Marc talked about, where we simply just charge the monthly fee. You're going to be dealing with myself or someone else on my team, and as much as possible, you're going to be dealing with the same lawyer. Once you've dealt with one lawyer, we're going to try to make sure that you're going to continue dealing with that lawyer going forward, and we will try to make it as simple as possible for you to be able to follow up with us by literally being able to book time with us in our calendars so that you can reach us when you need to reach us. And those are just some of the ways that that we're set up differently than a traditional law firm. And the other way that that I think is a real benefit is our relationship with HR Covered. So as Marc said, we work very closely together, and by combining HR professionals and legal professionals, we're able to provide, I think, best-in-class service for all of your workplace needs.
And wow, I think it's, and I had a legal matter when I was an employer in the past as well. And I remember looking at the bill, and I actually got charged for my lawyer sending me emails and printing documents. And to me, I was a bit shocked at that. But then again, refreshing to actually see such a different approach. So thanks for sharing, Anatoly. And also to help all of you get a taste of it and get some of your additional questions answered. We're happy to also provide all of you with a free consultation to go over those things. But more importantly, if you also see value in the service after that consultation and decide to move forward and take advantage of those, we'll also provide you with the first month at no cost. So great opportunity for you to be able to take advantage of the service, but more importantly, primarily to also be able to get to know where you stand as an organization, as a business, and get some expert advice as well.
Great. I think, Marc, thank you so much for that. I think it's time to answer some questions if we can.
Absolutely. So I do see a lot of questions. I will read them out in order. So we have a few. So I also will not forget Angela, who has a question in the chat. If possible, use the Q&A bubble at the bottom of your screen. That's the one that we'll be mostly monitoring here. So we'll start with the first one, which is, it is my understanding of the ESA that construction workers are exempt from termination notice and pay given the nature of the business. Can you please verify that? Does that mean an employer in the construction industry can legally terminate employees with or without cause at any point in time, regardless of how long they have been working at the company?
Yeah, it's a great question. I don't have a name for that question, but there are. Let me put it this way. So. Very happy to answer questions, general questions and questions of this nature, but I would encourage anyone who has sort of specific questions like this to come and talk to us afterwards. And the reason for that is the ESA does have various exemptions in it from the minimum standards. And so there are, this person's absolutely correct, there are exemptions for construction workers. There's also exemptions for professionals such as lawyers. So not everyone is subject to the ESA, but if you were in a specific industry that you think might be exempt and you're wondering what the, I don't have time to get into all the specifics for every industry during this webinar, but if you have specific questions and you're in an industry where you believe your workers are exempt, then absolutely, by all means, get in touch with us. And I will also say, we didn't talk about unionized environments. Unionized environments are also treated differently because they're subject to a collective bargaining agreement that kind of determines everything between the employer and the employee.
Thank you, Anatoly. And the next question is actually on the chat from Angela, who was asking, we update employment agreements annually with wage changes. Is this not needed?
Angela, I don't think you have to, I do not think you have to, if that's the only change you're making, I don't think you have to update your employment agreements annually. And I assume when you mean wage changes, you mean increases in pay, so you're not taking anything away from the employee. I don't believe that requires a whole new agreement. Although there's nothing wrong with doing that, it does give clarity, written clarity to everybody, and because you're actually giving the person extra money, they are getting consideration, so there would be validity to the agreement. But do you have to do it? No, I don't think you have to do it.
Thank you, Anatoly. Now, next question is from Hannah on the Q&A. What is the court decision which states temp leaves could not be constructive dismissal if it is contained in an employment contract?
Yeah, so actually there's a long line of decisions that state that unless the temporary leave is contracted for, it is considered to be a constructive dismissal. There was a recent decision, I wonder if this is what the person's talking about. There was a recent decision, it's called the Taylor decision, where the Court of Appeal everyone was expecting the Court of Appeal to give an opinion as to whether or not the IDEL leave that Ontario put in during COVID, and which the legislation actually said that it should not be a constructive dismissal, how the courts were going to interpret that. Unfortunately, the Court of Appeal declined to decide the case on that basis, and so that leaves us with two other lower court decisions, which so far it's 2-0 on the side of the employees, which basically say that if you're put on temporary leave, it is a constructive dismissal unless your contract allows for it.
Thank you, Anatoly. Now we have a question from May, and the question is, if when adding the pandemic statement to the contract, and this is the only change, should employees all sign new contracts, and would we be required to give them compensation?
So I'm wondering if May means by this what we were just talking about in terms of the pandemic statement. I'm not entirely sure if May's talking about the ability to put someone on a temporary leave without it being a constructive dismissal. But if so, then yes.
Oh, she said yes. Yeah.
Okay. So if that's the case, then yes, that all employees, if you do want to put that, and I do think it's a good idea because nobody knows what reason you might have to put someone on a temporary leave. But I do believe that everyone should be getting an employment contract with the ability for the employer to put the employee on a temporary leave without it being a constructive dismissal. And then, yes, the employees would have to be given some sort of compensation to sign that new agreement. Now, it doesn't have to be a massive amount of compensation, but it does have to be something valuable. It could be an extra vacation day. It could be extra sick days. It could be a number of different things, a one-time bonus. But yeah, that's correct. You would have to give some compensation in order to make that contract valid.
Thank you, Anatoly. And now we have a question here which says, when an employee abandons the job without resigning, how is the employer supposed to treat this? Should the employer issue a letter of termination?
That's a really interesting question. So by abandons the job, I assume what the writer means is the employee simply leaves and they don't actually provide any written notice of the resignation. They just don't show up for work anymore. I would say then yes, you should issue a letter of termination. And well, actually, let me take that one back. Maybe not, because if you terminate the employee, depending on the situation, there might be implications for the employer in terms of termination pay. So if the employee abandons the position, then the employer can simply just treat that as a resignation. And if it's a resignation, then the employer does not owe the employee anything. So what you should do is document that, treat it as a resignation, document it, send a letter saying that you have abandoned your position and we are going to be treating it as a resignation. If that is not your intention, please notify us and by a certain date and let us know that is not your intention to do so.
So there will be multiple touch points in a case like this to basically justify on the employer's side that this would actually be seen as a resignation, right?
Yeah, absolutely. Because you can't if somebody doesn't show up, let's say for 1 week and they haven't communicated, well, you don't know. Maybe something happened to that person. Maybe the person got injured. Maybe they're in the hospital. They've been unable to communicate. You don't know what's going on. So I do think there's an obligation. It's a difficult one to deal with, but I do think there's an obligation on the employer to, as you say, Mark, have several touch points with the employee and have a documented trail trying to ascertain exactly what the employee's intention is. Now, if after a long period of time there's simply no communication, at some point the employer is entitled to treat the contract as being frustrated and therefore at an end and treat it as a resignation. But that is one that you would want to get specific legal advice on for your situation.
Thank you. And now we have a question about toxic work environment. How is it defined?
Yeah, there's no one definition for that. Great question, though. I mean, because it's a bit subjective. What's toxic for one person may not be toxic for another person. And when I use the words toxic work environment, that's not really there's no, when we're talking about constructive dismissals, it doesn't use that terminology. It simply means that it's not tenable for the employee to continue working in that workplace. So it could be that the employee is getting harassed at the workplace. It could be that a manager is screaming at them on a regular basis. It could be that the employee is being left out of every important project and they're not being able to do anything about it. There could be a number of different situations, but I've certainly dealt with enough employees and employers to know that what in one person's estimation is a toxic work environment that is no longer tenable for them to work at may not be the case for another employee. So there is a bit of subjectivity to it. There's no objective definition, unfortunately.
Thank you. And now we have a question about termination without cause. If they follow the probation clause in the employment contract, is that fine even if it says no notice is to be given? Or does it actually really depend on the quality of the termination clause in the actual contract of employment?
Yeah, it's a good question. So so first of all, let's say in Ontario, under the Employment Standards Act, in the first 3 months, there is no requirement to give notice or pay in lieu of notice under the ESA. However, unless you have a termination clause in your employment contract that limits the employee to the ESA, then technically you're under the common law, and under the common law, you would owe some sort of notice and some sort of pay in lieu of notice. So I'm not entirely sure if I understand this question perfectly, but if you do have a probationary clause in your employment contract and a valid termination clause, you should be able to follow that probation clause so long as it's not giving less than what's in the ESA. I hope that makes sense.
It did to me, but and
Okay.
Samir, if you have any further questions on that point, you can send us your contract of employment as well, or take us up on our offer, and we'll review those case by case with you, and give you the best possible advice as well. Now we have what if there are outstanding earned but not paid sales commissions? Is the employee entitled to receive those?
Yeah, I think, again, maybe a little bit more context would be helpful here, but I am assuming what this person means is that the employee has been fired for cause, and they're wondering whether or not they have to pay them the sales commissions that they've earned but haven't been paid yet. My answer to that would be, in that situation, yes, you would, because it's no different than if that's part of their compensation and they've earned it before termination, then they're entitled to it.
And then I guess if the person was to resign, then I guess it would depend on the wording that people actually have in their agreement or in their commission plan with their employees.
That's correct, and I mean, if you have employees on commissions, that's another really good reason to have all of that clarified in an employment contract.
Good. And a question from Andrea, who says, basically, under COVID, we temporarily laid off 5 employees due to a reduction in business 5 months ago. If those employees found other employment because it's been so long, do we owe them pay in lieu of notice or severance pay or termination pay after the fact? And then she says, we still intend to call them back as soon as we can when business picks up again.
Yeah, really. So that touches on a couple of things, and I didn't talk about mitigation during the presentation, but mitigation is a principle that basically says where if an employee has been let go, whether it's a direct termination or whether it's a constructive dismissal based on a temporary dismissal or temporary leave of absence that they've been put on. The employee is obligated to try to mitigate their damages, and the way to mitigate your damages as an employee is to look for other employment. So to the extent that the employees were able to mitigate their damages, that will be subtracted from what you might owe them. Now, in terms of whether you owe them pay in lieu of notice or severance pay, technically the answer, if there was no employment contract that allowed you to do so, technically the answer is yes, but it's not like I'm not suggesting that you should call them up and offer it to them, but if you're asked for it and you receive a letter from the employee or from the employee's lawyer, then the answer is yes, you would owe them, but mitigation could be part of the equation, because to the extent that they mitigated, it will subtract from what you owe them. But if they failed to mitigate whatsoever, meaning they didn't even try, that there's also a subtraction for that. So again, facts become really, really important in these cases.
Fantastic. Thank you so much, Anatoly, for all those insights. And as a reminder for everybody, a copy of this webinar will actually be sent to all of you. So we will receive the recording. So we'll have all the answers to all the questions and all the great content Anatoly shared today as well. There will also be someone from our team who will also call every attendees to make sure, if you want to take us up on our offer to get to know a little bit more about what you have in place now and what you should have in place to better protect your business, or about our services, we'll be happy to share that information with you as well. So if there is no further questions, we want to thank you all for your time. Thank you, Anatoly, as well, for sharing your knowledge with everybody today. And,
yeah, my pleasure, everybody. And thank you all for joining us. I know everyone's busy, and it's really great of you to take some time to learn about terminations today.
Absolutely. Thank you all very much.
Bye for now.